Me out there?
Good morning, Mr. Chair.
Good morning, Commissioner Hall.
How are you?
Is everybody ready to go?
So,
Well, yesterday was 2/22/22. Was there any anomalies, anything out of the ordinary on 2/22/22?
adoptions.
All right, enough about my question. It's 9:30 on the dot. This is Joseph Maestas, Chair of the Public Regulation Commission. I want to welcome everyone that are tuning in to the regular weekly meeting of the New Mexico Public Regulation Commission. And Russell, you will be helping us with roll call and roll call votes. So I want to call this meeting to order. Russell, please take the roll.
Yes, Mr. Chairman. Commissioner Hall,
Here.
Commissioner Vicente Aguilar,
Here.
Commissioner Fishman. Okay, I'll go back. Mr. Chairman.
Here.
Commissioner, yes. And Commissioner Byrd.
Present.
Let me try Commissioner Fishman again. Commissioner Fishman, are you present? Okay, Mr. Chairman, we have 4 commissioners present. That's a quorum, so we may go forward.
Thank you, Russell. And I just want to let everyone know Commissioner Fishman has notified me that he will participate later on in the meeting, likely for agenda items 8 and 9. Okay, with that, Vice Chair Hall, do you mind leading us in the Pledge of Allegiance and the State Pledge?
Not at all. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, the Zia symbol of perfect friendship among united cultures.
Thank you, Vice Chair Hall. Okay, next agenda item is consideration and approval of the agenda. I have a couple of amendments I'd like to suggest. One is to pull item 4 under utility matters under consent agenda. There are 2 orders, a version 1 and a version 2. And I just want a clarification on which one is recommended by Office of General Counsel. And then I'm pulling item 10 under discussion and potential action in the matter of an inquiry into New Mexico electric utility resource adequacy planning and impacts of global supply chain disruptions. We were working on a response to the Attorney General's open letter dated February 15th. It's still in draft form, so we will take it up at the next meeting. Are there any other suggested amendments to the agenda? If not, do I hear a motion to approve the agenda as amended?
So moved.
So moved.
Okay, we have a motion on the floor by Commissioner Byrd and a second by Vice Chair Hall. Any discussion on the motion? All right, Russell, please take the roll call vote.
Commissioner Byrd.
Aye.
I'll skip Commissioner Fishman. Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
Aye.
And Mr. Chairman. Mr. Chairman, Commissioner Maestas.
Aye. Did you not hear me?
I did not. I hear you now, though.
Okay, thank you.
Okay, so the agenda as amended is approved 4-1, or 4-0, I'm sorry, with Commissioner Fishman absent.
Thank you, Russell. Let's move on to introduction of special guests. Sarah or Russell, do we have any special guests?
Mr. Chair, this is Isaac. I'm filling in for Sarah today. We do not have any special guests or public commenters today, so we can go on to agenda item Roman numeral 6.
Okay, thank you, Isaac. Let's do that. So item 6 is a presentation from Renata Piri-Galone regarding FY22 surplus vehicles. Ms. Renata, take it away.
Morning, Mr. Chair and Commissioners. Isaac, are you able to share that PDF on the FY22 fleet surplus vehicles?
Yes,
Thank you.
one moment.
So while Isaac is pulling that up, I am bringing for approval this morning to the Commission the surplusing of 11 vehicles, 9 which are currently in PRC fleet checkout, and 2 which are vehicles that were state fire marshal vehicles that were missed in the surplusing of vehicles in fiscal year 21. So you see before you the list of vehicles that we are bringing to the Commission for approval to surplus. These are vehicles that either have higher miles, have been underutilized, or have maintenance issues. With the surplusing of these vehicles for PRC fleet checkout, it would bring us down to 4 vehicles, of which there would be 1 Dodge Caliber and then 3 Honda Civics that are all hybrid vehicles. I do want to note, since July of 2020, in our vehicle fleet, the PRC fleet checkout, we've only had 3 vehicles checked out in that year-and-a-half period. So, this is why we're bringing to you the recommendation to surplus these vehicles. We do put in place a PO of $5,000. These vehicles still have to be maintained annually, tires, anything that comes up maintenance needs wise, because we do have hybrid vehicles and we have not been checking out vehicles a lot. We do have to maintain those vehicles, and we have a staff member, an ASD, that routinely will drive those vehicles just to keep them charged. At this point, I will stand for any questions pertaining to the list that's being recommended.
Thank you, Renata. Any questions for Renata regarding these recommended surplusing of state vehicles?
Mr. Chair,
Commissioner Byrd.
thank you. Good morning, Renata. How does our usage compare to like 2018, 2019 levels?
Mr. Chair, members of the Commission, I don't have numbers that go back to that or historical knowledge of how much was used pre-pandemic, but I do have a sense that business has changed through the course of COVID for a couple of reasons. We're seeing more and more trainings and business being done virtually, even during times where I know we've been kind of up and down with where we've been with COVID, but it seems that there's a lot more that's being offered in a virtual environment, which has reduced the need for travel. But also, there's also the issue of all of our vehicles are in Santa Fe. And right now we have people that are teleworking even in Albuquerque. And for instance, because of that need of having people in Albuquerque and our vehicles are here, I have had discussion with some division directors that there are motor pool vehicles available through General Services TSD, Transportation Service Division, where we can do short-term leases on those vehicles. And they even have a program that's called Quick Ride, where it's $3.88 an hour to basically utilize one of those Transportation Service Division vehicles. That $3.88 an hour encompasses even fuel. So that is something that I see that we potentially, with people teleworking in Albuquerque, will have that need for them to have access to the motor pool through TSD for short-term leases. And it reduces the need for how many vehicles we need here in Santa Fe.
Answer. Sorry, good answer. I like that. So what happens to these cars now?
So upon their approval, Mr. Chair and Commissioners, upon the approval by the Commission, we will be in contact with Transportation Services Division on the surplusing of these vehicles. And we also have to submit a letter to the Office of the State Auditor in regards to the vehicles that we surplus.
So no monetary benefit to the agency, to our agency.
Fortunately, no.
Darn it. Okay, that's it for me, Mr. Chair. Thank you.
Thank you, Commissioner Byrd. Any other questions for Renata?
Mr. Chairman,
Yes, Commissioner Vicente Aguilar.
thank you. Renata, I was just wondering if you have checked with the with staff members or division directors, if they are interested in signing up for a state vehicle, or if they have one for their division, they want to continue to use it just in case there's more outreach for 2022?
Mr. Chair and Commissioners, we will still have 4 vehicles within the PRC fleet for checkout. And there will be access to also, for those that are in Albuquerque, to utilize the short-term leases through GSD's Transportation Services Division. I'm also accounting for when the commission goes from 5 to 3, we're going to be adding 2 vehicles and we'll be up to 6 vehicles in the fleet checkout. My sense is that that is going to be an adequate number, even as we move forward for checking vehicles out of this building as needed.
Okay, thank you.
Any other questions for Renata? All right, then this is an approval item. Do I hear a motion to approve the recommended disposition of surplus vehicles as presented?
So moved.
Okay, we have a motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Russell, please take the roll call vote.
Commissioner Fishman. Oh, I'm sorry, Commissioner Fishman is still absent. Commissioner Maestas.
Aye.
Excuse me, Mr. Chairman. Commissioner Hall.
Aye.
Commissioner Vicente Aguilar.
Aye.
And Commissioner Byrd.
Aye.
Okay, so the action recommended by our ASD director is approved 4-0.
Thank you, Mr.
Thank
Chair.
you.
Thank you, Commissioners.
Thank you, Renata. All right, let's move on to item 7, consideration and approval of prior meeting minutes. Before I ask to entertain a motion, are there any suggested amendments to the minutes of the November 1st, November 10th, and February 2nd, 2020? I'm sorry, November 1st and November 10th, 2021 open meetings, or the minutes for the February 2nd, 2022 open meeting? Any amendments suggested?
Mr. Chair.
Yes, Commissioner Byrd.
Thank you, Mr. Chair. Is Mr. Boaz on? As he scrambles to find that button.
I am on.
Hi, Carl.
Good morning, Carl.
Good morning.
I just want to say good morning. I haven't seen you in a year and a half. I hope you're doing well. Thank you, Mr. Chair.
All right, if there are no amendments, then I believe it's permissible to approve all those minutes with one motion. So do I hear a motion to adopt the minutes of the November 1st and November 10th, 2021 open meetings and the minutes of the February 2nd, 2022 open meeting?
So moved.
So moved.
Okay, we have a motion and a second. Any discussion on the motion? Okay, hearing none. Russell, please take the roll call vote.
Commissioner Vicente Aguilar.
Aye.
Commissioner Byrd.
Aye.
Commissioner Hall.
Aye.
Mr. Chairman.
Yes.
And I believe Commissioner Fishman is still absent. So the vote is 4-0 to approve the minutes of November 1st, 2021, and the minutes of February 2nd, November 1st and 10th, 2021, and the minutes of February 2nd, 2022.
Thank you, Russell. Let's move on to item 8, consent agenda item. As you know, we amended the consent agenda to pull item B4 in the case of 21-318-UT. So with that, do I hear a motion to approve the consent agenda as amended?
So moved.
Second.
Okay, we have a motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Before we take a roll call vote, Russell, do you mind reading the consent agenda items, the captions?
Yes, I will do so, Mr. Chairman. Let's see. All right. First, we have docket number 22-00019-TR-M. That is in the matter of the application of White Glove Moving Services LLC for a certificate to provide household goods service. Then we have docket number 19-00106-UT in the matter of applications for 2020 broadband program support from the State Rural Universal Service Fund as per 17.11.10.31 NMAC. We have docket number 21-00259-UT in the matter of the formal complaint of George Baca and Maria J. Baca against Navapache Electric Cooperative. We have docket number 21-00318-UT and the matter of a request for approval of general rate adjustment pursuant to 17.9.540. And
Commissioner Byrd.
we have
That was removed.
I'm sorry. Oh, I'm sorry about that. I'm sorry. That was removed. I apologize for that. So strike that. We have docket number 22-00017-UT in the matter of Southwestern Public Service Company's application for authority to, 1, issue up to $250 million of first mortgage bonds during 2022. 2, recover certain refunding costs. 3, enter into agreements in support of interest rate hedging, including interest rate locks and swaps. And 4, extend authorization to issue notes under revolving credit agreement for an additional 3 years. We have docket number 22-00018-UT in the matter of the application of New Mexico Gas Company, Inc. for a variance from 17.10.640 NMAC for its February 2022 gas cost factor statement. And that is it, Mr. Chairman.
Thank you, Russell. So we have a motion on the floor and a second. Any further discussion to approve the consent agenda as amended? Okay, Russell, please take the roll call vote.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar.
Aye.
I will skip Commissioner Fishman. Mr. Chairman. Mr. Chairman, I don't hear you.
Aye.
And Commissioner Byrd.
Aye.
So the consent action agenda items as amended are approved 4-0, Mr. Chairman.
Thank you, Russell. And when I made the motion to remove item B4 from the consent, I didn't indicate where it would land under the regular action items, but if there's no objection, can we hear it first up under regular action items? Any objection to that? Okay. All right, so this is a pulled item. It's in the case 21-318-UT in the matter of request for approval of general rate adjustment pursuant to 17.9.540. Hemis Mountains Electric, Inc. is the petitioner, and we will be considering a recommended order. I don't know if it's version 1 or version 2, so I'll let Judy maybe tee up the case and then just clarify the 2 different
Yes.
orders. Go ahead, Judy.
Thank you, Mr. Chair and members of the commission. This matter comes before you today upon, as Mr. Chair stated, the application of Hemis Mountain Electric Cooperative for a rate increase. And the reason that there was a second version sent to the commission after Friday was that on Monday, the commission received a motion from New Energy Economy for leave to intervene and for expansion of the service list, and a request that all the parties be served all discovery requests and responses to the council for NEE. NEE requested permission to intervene on behalf of the following persons and organizations. There were HAMUS member residential ratepayers, Loida Martinez, Gilbert Sanchez, Tom Engel, I'm gonna make a mistake in pronunciation of this name. Sarawati Kaur Khalsa, Trenton DeVore, Theodore G. Roybal, Sarah Duke and Charles King, Bruce David and Marcia Rinkman, Mark Steiner, and Florence P. Jaramillo. The three preceding listed were part of the original group of protesters. Also, on behalf of Daniel Ernest Sao, Navajo Nation Council Delegate Chair, on behalf of the Hispano Roundtable de Nuevo New Mexico, on behalf of Honor Our Pueblo Existence, also known as HOPE, on behalf of Indigenous Lifeways, Inc., on behalf of Institute for Local Self-Reliance, and on behalf of New Energy Economy, on behalf of Rio Arriba Concerned Citizens, and on behalf of Tewa Women United. The change to this order does not make a ruling on NEE's motion to intervene. Rather, it requests that within 1 week, HAMUS Mountain file its objection, and then following that, staff shall file a response to both NEE's motion and a reply to HAMUS Mountain's objection. And then after that, NEE will be allowed to file a reply to both HAMUS's response and objection and staff's response. And after that, the commission will make a ruling on that. So that's the change to the order from Friday. Do you want me to go through what the rest of the order stated originally?
Yes, please.
Okay. The original order essentially followed what staff recommended, which was that there were the sufficient number of valid timely protests. There were they made a lot of findings. They recommended that the commission not grant HAMUS Mountain's requested variance to use a 2019 base period and not authorize HAMUS Mountain to use an adjusted base period for the cost of service study that they did file. And they asked the commission, they recommended that the commission order HAMUS Mountain to file an updated cost of service study that complies with the commission's rules and uses the most recent possible 12-month period, not 2019. And they go through a variety of reasons that they make this recommendation, which I can outline, but it's detailed in your memo and your order. And therefore, the commission agreed with the reasons, essentially, that the 2019 base period is not representative of what the current, the previous year's situation with HAMUS Mountain actually is, and probably is not representative of what's going forward, since it's lost a lot of customers that may not come back. And staff believed that an updated cost of service study based upon the utilization of a base period as you know, preceding the application would more accurately reflect the current situation that Jemez Mountain is undergoing and probably will continue to for the near future. So for all those reasons, the commission previously suspended Jemez Mountain's proposed rates as filed in Advice Notice 116. But at this point, the commission should toll the suspension period pending Jemez Mountain's filing of an amended application with an amended, updated cost of service study as described in staff's response. And the tolling shall continue until staff files its determination that the amended application complies with this order. And therefore the order denies Jemez Mountain's requested variance to use the 2019 base period and their request for a variance from the definition of base period. But does allow the order does authorize Jemez Mountain to use an adjusted base period and as utilizing the most recent 12-month period as possible, as staff stated. And then within 10 days of Jemez Mountain filing an updated cost of service study and amended application, staff will review and analyze and file a determination of compliance with this order. And that is a summary of the order and the changes that were due to the recent filing of NEE's motion to intervene on Monday.
Thank you, Judy. So just to clarify, it's version 2 now that you're recommending.
Yes, it doesn't make a determination on NEE's motion. It asks for essentially objections to be filed and responses to objections.
Okay, any questions for Judy on this case, on the action, on the proposed order, which is version 2? All right, if there's no further questions, do I hear a motion to approve version 2 of the order?
Mr. Chair, I'll move the order.
Okay,
Second.
we have a motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Russell, please take the roll call vote.
Mr. Chairman. Commissioner Byrd.
Aye.
I'll skip Commissioner Fishman. Commissioner Vicente Aguilar.
Aye.
Commissioner Hall.
Aye.
And Mr. Chairman.
Aye.
Mr. Chairman, the order is adopted 4-0.
Thank you, Russell. Let's move on to the next agenda item under regular action. This is under utility matters, case 18-211-UT in the matter of the formal complaint of Resolute Wind 1 against Lee County Electric Cooperative, Inc. And we will be considering a potential order on remand. Judy, before we begin, I just wanted to ask the question about a potential closed session if you think that it's needed. It's not noticed, but my understanding is that we can go into closed session if necessary and alert the Attorney General of this change post meeting.
Mr. Chair, members of the commission, this matter has been in litigation, as you can see, since 2018. It went on appeal to the New Mexico Supreme Court. Briefs were filed, oral argument was held last summer. The court issued an order on February 9th. And I would recommend going into executive session if the commission would like to discuss the case, the order that was issued by the Supreme Court, which vacated and annulled the commission decision. The mandate, which is a procedural order issued by the Supreme Court, is to be issued in 15 days, which is tomorrow, February 24th. So the date of this order would not be until the mandate is issued. And therefore, it's still considered pending litigation. So I would recommend going into executive session.
Judy, I noticed that there was a placeholder here. The issue was our senior hearing examiner, Ashley Schanauer, was to appoint a hearing examiner to preside over this. Has that recommendation been made, and has the recommended order been updated to reflect the recommendation of a hearing examiner to preside?
Mr. Chair, members of the commission, I requested a hearing examiner from Chief Hearing Examiner Ashley Schanauer, who stated that he did not have a hearing examiner yet named, and requested that I insert into the order that the hearing examiner would be named by subsequent single signature order.
Okay, I think before we go into closed session, Judy, if it's okay, I'd like to just query the commission if they have a desire to go into an in-depth discussion about this case. And also, I don't have a motion before me to go into closed session, so I may, if there is a desire to go into closed session, I'd like you to maybe read out the motion to go into closed session. And I'm happy to make it, or if you want.
The motion would be, I believe it's pursuant to Section H, and I have to get the numbers of the Open Meetings Act regarding pending litigation. And let me look that up. Well,
This is Michael Smith. That would be section 10-15-1H7.
okay.
And Mr. Chairman, Commissioners, I just wanted to clarify that this is a matter that does appear on the commission's agenda, and the commission under the Open Meetings Act can close any matter that appears on the agenda, provided that there is a proper basis to do so, to close rather the discussion based on the exceptions outlined in the Open Meeting Act. So it does not require a notification to the Attorney General. That would only apply if the commission sought to add something to the agenda without the proper notice to the agenda and address something in the open meeting. And that those kind of actions would require a notification to the Attorney General, and they have to constitute an emergency under the Open Meeting Act, a permissible emergency situation.
Yes, thanks, Mike. I was going to say that this matter is on the agenda, and we can go into executive session on any matter noticed. And it's 10. So Commissioner Maestas, I would make a motion pursuant to Section 10-15-7. Sorry. Here goes. 10-15-1H7. To go into closed session.
Okay, do I hear a motion to go into closed session? Pursuant? Yes.
Yes, so moved.
Okay, motion by Vice Chair Hall. Do I hear a second? I'll second that. Any discussion on the motion? All right, Russell, please take the roll call vote.
Commissioner Vicente Aguilar,
No.
Commissioner Byrd,
Yeah, yes, aye.
Commissioner Hall,
Aye.
Mr. Chairman.
Aye.
And I believe Commissioner Fishman is still absent, I believe. Okay. So, Mr. Chairman, the vote to go into executive closed session pursuant to Section 10-15-1H7 of the Open Meetings Act is approved 3-1.
Okay, great. Thank you, Russell. So Isaac, you'll move us into another room.
I am sending you all in now.
Can you all hear me? We're back in the hearing room.
We can hear you, Mr. Chair.
Okay, thank you. We're just allowing folks to return to the hearing room. Bear with me.
Mr. Chair, this is Commissioner Fishman. I'm here now.
Yes, let the record reflect Commissioner Fishman has joined us. Welcome, Commissioner.
Sorry to have missed the bulk of the meeting here.
No worries. Okay. We're back in open session. Do I hear a motion to go back into open session pursuant to 10-15-1 H Prin 7 in the matter of the formal complaint of Resolute 1 against Lee County Electric Cooperative? And I want to state for the record that the discussion was limited to the topic as included in the agenda and that no decisions were made. Do I hear a motion?
So moved.
Second.
Okay, we have a motion by Vice Chair Hall and a second by Commissioner Byrd. Any discussion on the motion? Russell, please take the roll call vote.
Okay, yes, Mr. Chairman, before I do that, if you could also confirm that only matters within the ambit of section 10-15-1 H7 of the Open Meetings Act were discussed.
Yes, is the maker of the motion and the person that made the second, is that okay?
Yes.
All
I
right,
believe that was stated.
okay.
All right,
All right.
I will take the roll, Mr. Chairman, yes. Commissioner Byrd,
Aye.
Commissioner Fishman,
Abstain.
Commissioner Vicente Aguilar,
Aye.
Commissioner Hall,
Aye.
and Mr. Chairman.
Aye.
Thank you for abstaining, Commissioner Fishman. That's a good point. Since you didn't vote to go into executive closed session, I appreciate that you abstained. Thank you.
Right, thank you.
Okay, Judy?
Yes, the proposed order in accordance with the opinion and order issued by the Supreme Court on February 9th, 2022 would remand the case back to a hearing examiner to be named by subsequent single signature order for a full evidentiary hearing. It would also vacate and annul the final order issued in this matter. And the effective date of the order would be that the date that the commission actually receives the mandate, which will be issued by the Supreme Court. That's another procedural step that has not occurred yet, and should occur anywhere between 15 days after the final order, which is February 24th, or it could be longer than that, depending on the Supreme Court's schedule.
Okay,
So that's the final order. There's not a name of a hearing examiner, but it does remand to a subsequently named hearing examiner for an evidentiary hearing and the issuance of a recommended decision. And the effective date would be the date of the mandate from the Supreme Court.
okay, so we have a proposed order with some amended language that Judy just laid out. Any other discussions for Judy? If not, do I hear a motion to adopt this order as amended?
Mr. Chair, I'll move the order.
Okay. We have a motion by Vice Chair Hall. Do I hear a second?
I'll second.
Second by Commissioner Byrd. Any discussion on the motion?
Mr. Chair,
Commissioner Byrd.
thank you. So I just want to say that the whole rule that this process is being brought up goes against the foundations and principles of a free market. And this is an outdated rule that somebody really needs to take the reins on and update, it does not make sense to force people to buy a product that may end up being more expensive than the alternatives. And that just does not meet the definition of a free market. However, it is the rule, the law right now. And so we will move forward with this order, and that's why I seconded it. Thank you, Mr. Chair.
Thank you, Commissioner Byrd. Any further discussion? We have a motion on the floor and a second to adopt the order as amended. All right, Russell, please take the roll call vote.
Commissioner Basenti Aguilar,
Aye.
Commissioner Byrd,
Aye.
Commissioner Hall,
Aye.
Mr. Chairman,
Aye.
and Commissioner Fishman.
Abstain.
Mr. Chairman, the vote is, excuse me, 4-0 in favor of adopting the proposed order as amended.
Thank you, Russell. Let's move on.
Mr. Chair,
Yes, Commissioner Byrd.
is that the correct reading of the vote?
Commissioner Byrd, with regard to the abstention by Commissioner Fishman, is that correct?
Sir,
I could read, I'm actually not sure. I'll read it. I can read it differently as well. Four in favor and one abstention. I can read it. I'm not sure if there's a particular requirement for how to read that, but that is more specific. So yes. So I can re-report that. Mr. Chairman, the vote is 4 in favor of the amended proposed order and 1 abstaining.
thank you, Mr. Chair. I just liked hearing myself talk.
That's one.
That makes one of you. Simmer down. That's what my dad would tell us when we were kids. Simmer down.
Gotta have some fun.
All right. Let's move on to the crescendo of this meeting. It is an agenda item in the case of 19-00018-UT. in the matter of Public Service Company of New Mexico's abandonment of San Juan Generating Station Units 1 and 4. And we will be taking action on a potential order. Michael Smith, do you want to tee this up for us, please?
Yes, Mr. Chairman, Commissioners. I don't know if everybody wants to hear me talk, but I'm having a little difficulty today, so I'm going to try and save my voice because I'm going to read the pertinent portions of the order that I have, but I will just summarize it very briefly to say that the proposed order I prepared would find that PNM's request for modification to the Commission's final orders or a variance from those final orders to provide authority for it to extend the service of the San Juan Generating Station Unit 4 is not required, and a hearing is not required on this. And I will explain that in this order. I'm going to read it so that I think might have the press listening. I think we have a number of parties will be listening. So I'll just read through the pertinent portions and hope my voice holds out. PNM's notice of Public Service Company, PNM's notice of Public Service Company of New Mexico and request for any necessary modification to or variance from abandonment date of San Juan Generating Station Unit 4 notified the Commission of its determination that it is necessary to temporarily extend the closure date of San Juan Generating Station Unit 4 for an additional 3 months to meet system resource adequacy needs for the summer 2022 summer peak. I misstated that. Due to delays to the commercial operation dates of the replacement resource projects approved by the Commission to replace the generation capacity of San Juan Generating Station Units 1 and 4 in companion case 19-00195 UT, resulting from pandemic-related supply chain interruptions and delays. PNM's request seeks, quote, any such order as the commission may deem necessary under Rule 12240 NMAC to authorize an extension until September 30th, 2022. PNM requests, quote, a modification to or variance only to the extent that the final order on abandonment requires PNM to cease operating San Juan Generating Station Unit 4 on or immediately after July 1st, 2022. PNM's prayer for relief requests that, quote, the commission, one, accept this notice as all that is necessary under the final order on abandonment, or grant PNM's request for variance or modification to the final order on abandonment. In response to this application, on February 17th, the commission issued an order for responses to PNM on its request, which required that the responses state, issued an order for responses to PNM's request, which required that responses state if the parties in this case oppose or support the relief sought in the request. On February 18th, 2022, the commission also issued an order requiring responses from PNM requesting additional information in support of PNM's request. Of the parties responding to PNM's request, Bernalillo County, the joint respondents, who are made up of the Coalition for Clean Affordable Energy, CCAE, Western Resources Advocates, WRA, and the Sierra Club, the New Mexico area, which is the acronym for the New Mexico Affordable Energy Reliance, the Office of the Attorney General, and the commission staff indicated that they support PNM's request, but assert that the commission should, I'm sorry, there's a typo there, provide an opportunity for, sorry, that's a typo, I'm going to remove that. Onward Energy, Interwest Energy Alliance, and New Energy Economy either take no position or assert an inability to take a position without additional information. Onward reiterates its willingness to explore opportunities to address incremental capacity and interconnection issues that may permit it to address PNM's capacity shortfall issues. New Energy Economy's response argues that there should be an opportunity for discovery and briefing, but New Energy Economy's pleading is unclear about whether it ultimately seeks an evidentiary hearing or a determination on the briefs. Other parties also express an interest in obtaining information relating to the prudence of PNM's actions, the reasonableness of costs associated with PNM's extension of San Juan Generating Station. Several parties note that a formal evidentiary hearing is not required under Rule 12240D, which governs requests for variances and provides that the commission may, at its discretion, require an informal conference or formal evidentiary public hearing prior to making a determination. The February 21st, 2021 response of the Office of the Attorney General, quote, supports PNM's request that the commission take prompt action deemed necessary, with the understanding that a commission order granting a variance is necessary on or before March 25th, 2022. The Office of Attorney General further asserts, the Office of Attorney General intends to participate in any proceeding on PNM's request so as to get answers to the questions raised in our open letter to the commission dated February 15th, 2022 regarding resource planning deficiencies and emergency preparedness. Those questions include, but are not limited to, whether there exists the necessary staffing levels for operating the plant, whether the necessary negotiations with local labor groups are underway, and whether adequate safety protocols are in place should San Juan Generating Station fail. On February 22nd, 2022, the commission issued an order requiring PNM to confer with the Office of the Attorney General and file verified responses, noting that the parties in an adjudicative matter are not subject to the same ex parte restrictions on direct communications that PNM and the Office of Attorney General should confer immediately about the issues that the Office of Attorney General raises in its response in order to facilitate the full and expeditious disposition of PNM's request within the limited time frame available. Pursuant to that order on February 22nd, 2022, PNM filed its verified response to that order, confirming that PNM representatives had conferred with Assistant Attorney General Kevin Gedko and addressed issues raised during the conference and in the Office of Attorney General's February 21st, 2022 response. The joint respondents argue that a variance or modification is not required because the commission did not limit abandonment approval to a date certain in its order in case 19-00018, ordering paragraphs or other findings and conclusions. The commission in its case 19-00018 UT final order on abandonment states only that PNM's request is approved, and PNM's request states it intends to abandon on or about June 30th, 2022. That is a quote from the joint respondents. The commission agrees that the commission may act expeditiously on PNM's request without an evidentiary hearing. As noted, PNM's request seeks, quote, any such order as the commission may deem necessary under Rule 12240 NMAC to authorize an extension until September 30th, 2022. Rule 12240D governs requests for variances and provides that, quote, the commission may at its discretion require an informal conference or formal evidentiary hearing prior to making a determination. While on its face, PNM's request appears to satisfy the requirements of Rule 12240E for the granting of a variance, the commission agrees that PNM's request requires neither a variance nor a modification of the commission's final orders in this matter. The commission's interpretation of its final orders in this case finds that those orders do not mandate the abandonment of San Juan Generating Station Units 1 and 4 authorized by the commission take place by any date certain, and the continued use of San Juan Generating Station Unit 4 for the additional 3-month period would not require the modification or variance from any term of those orders. The April 1st, 2020 final order on abandonment adopted the terms of the February 21st, 2020 recommended decision, which recommended that the commission grant PNM's request for approval to abandon San Juan Generating Station Units 1 and 4. While PNM asserted throughout the proceedings that abandonment would take place on, quote, on or around July 1st, 2022, pursuant to the terms of its agreement with the other co-owners of San Juan Generating Station Units 1 and 4, the commission's final order on abandonment did not specifically require that the abandonment take place on that date. Likewise, the terms of the commission's April 1st, 2020 final order on request for issuance of a financing order adopted the terms of the February 21st, 2020 recommended decision on financing order, which in turn does not require that PNM issue the energy transition bonds authorized by that order by any specific date. Rather, the final orders in this case only dictate the conditions and terms by which the abandonment of San Juan Generating Station Units 1 and 4 and the issuance of the energy transition bonds must follow once the actions authorized by those orders actually take place. This conclusion is also consistent with the New Mexico Supreme Court's decision in State ex rel eGolf versus the New Mexico Public Regulation Commission, which is case number 2020 NMS Supreme Court 18, in which the court held that the provisions of section 6295, quote, logically refer only to voluntary actions by a public utility. PNM's implementation of its authorization to abandon San Juan Generating Station Units 1 and 4 remains a voluntary action by the utility under the final orders in this case. PNM's voluntary decision to extend the use of San Juan Generating Station Unit 4 also appears consistent with the principles of the Commuters Committee's test applied by the commission in determining whether a proposed abandonment is consistent with public convenience and necessity. Those factors are, quote, the extent of the carrier's loss on the particular branch or portion of service and the relation of that loss to the carrier's operation as a whole, 2, the use of the service by the public and prospects for future use, 3, a balancing of the carrier's loss with the inconvenience and hardship to the public upon discontinuance of service. And 4, most importantly, the availability and adequacy of substitute service. The default of the vendors of the replacement generation resources approved by the Commission effectively nullifies the 4th factor concerning the availability and adequacy of service. Moreover, no provision of the Energy Transition Act actually mandates that PNM abandon San Juan Generating Station Unit 4 by July 1st, 2022, or even by September 30th, 2022. While the Commission's final orders authorize PNM to undertake an abandonment of units 1 and 4 and issue energy transition bonds, the provisions of the Energy Transition Act, which establish the opportunity for a qualifying facility to recover energy transition costs through the issuance of energy transition bonds, are not mandatory. Section 6218(4)(a) provide only, quote, a qualifying utility that is abandoning a qualifying generating facility may apply to the Commission for a financing order pursuant to this section to recover all of its energy transition costs through the issuance of energy transition bonds. To obtain a financing order, a qualifying utility shall obtain approval to abandon a qualifying generating facility pursuant to section 6295. The application for the financing order may be filed as part of the application for approval to abandon a qualifying generating facility. The relevant portion of section 6218(2)(s) defines a qualifying generating facility as a coal-fired generating facility in New Mexico that may be composed of multiple generating units that, 1, has been granted a certificate of public convenience and for which abandonment authority is granted after December 31st, 2018. 2, is owned or leased in whole or in part by a qualifying utility. And 3, if operated by a qualifying utility prior to the effective date of the Energy Transition Act, is to be abandoned prior to January 1st, 2023. That's the provision that applies to this particular coal-fired resource. Accordingly, while section 6218(2)(s) sets a January 1st, 2023 expiration on PNM's status as a qualifying generating facility, and its correspondingly its authority to issue the energy transition bonds authorized by the Commission's final order on the request for issuance of a financing order, that limitation does not otherwise compel PNM to complete abandonment of San Juan Generating Station Units 1 and 4 by that date. The Commission recognizes that some parties have expressed an interest in seeking discovery relating to PNM's determination to extend the operation of San Juan Generating Station Unit 4. However, the Commission finds that the responses establish that the primary focus of those inquiries relates to the prudence and reasonableness of PNM's decisions and the possible cost effects that may result from PNM's determination to extend the use of San Juan Generating Station Unit 4. PNM's response to the Commission's February 18th request for responses addresses potential cost impacts. The proper proceeding to resolve such issues is in the proceeding in which such costs would be recovered, whether through normal rate procedures or the reconciliation process for energy transition costs addressed by the financing order. To the extent that any additional costs are incurred by ratepayers that would not be subject to correction in a rate proceeding, including additional costs recovered through the fuel clause, the Commission finds and puts PNM on notice that such additional costs will be collected subject to refund. While an evidentiary hearing is not required on PNM's request to extend the operation of San Juan Generating Station Unit 4, the parties' opportunity to conduct discovery related to their concerns about the prudence and reasonableness of PNM's decisions and possible resulting costs should not be delayed until the contemplated rate proceeding takes place. PNM's determination to extend the use of San Juan Generating Station Unit 4 is intended to alleviate PNM's issues in securing enough capacity to meet the summer 2022 peak. The extended use of San Juan Generating Station 4 will not resolve the underlying issues related to the supply chain issues that have caused the vendors of the replacement resources approved in case 19-195 to default and invoked the force majeure clauses in their contracts. There are ongoing concerns about PNM's ability to meet the summer 2023 summer peak, notwithstanding PNM's expressed belief that the replacement resources will be online by then, given that the Rockmont project remains in default and a substitute resource may need to be approved. While PNM has made compliance filings related to these replacement resources in the dockets for cases 2020-00182 UT and 19-00195 UT, the parties responding to PNM's compliance filings have raised a number of questions and concerns, but they have not had the opportunity to engage in discovery or pose questions direct to PNM directly. Accordingly, through a subsequent order to be issued by the Commission in either the 20-00182 docket or a new docket, the parties shall be afforded the opportunity, subject to the entry of an appropriate protective order, to conduct the requested discovery on issues related to the ongoing resource adequacy issues raised in PNM's compliance filings, as well as PNM's extension of the use of San Juan Generating Station Unit 4. This docket will also remain an appropriate forum in which the Office of the Attorney General can pursue the questions concerning public safety posed in the Office of Attorney General's response in the event PNM and the Office of Attorney General have been unable to resolve such issues through the conference required by the Commission's February 22nd, 2022 order. In conclusion, I would also note that the Commission notes that an executed copy of the Amendment Number 1 to the new exit date agreement amending and restating the amended and restated San Juan Project Participation Agreement, which is attached as Exhibit A to PNM's request, has yet to be filed in this docket. Therefore, the Commission orders that PNM shall file a copy of the executed agreement within 1 day of its execution. In the event any party to the amendment agreement gives notice that they will not execute the agreement as contemplated, PNM shall make a filing in this docket within 1 day of such notice, alerting the Commission so that the Commission and the parties can initiate immediate steps to address PNM's projected capacity shortfall for summer 2022. And I did not repeat this in the decretal paragraphs, and so I have made those findings and conclusions orders of the Commission through a provision that basically states that the orders and conclusions set forth above are adopted, incorporated herein as the orders of the Commission. And the additional decretal paragraph makes a order that in making the findings and conclusions and issuing this order, the Commission is not making any determination at this time with respect to the prudence or reasonableness of the decisions and actions taken by PNM, nor on the recoverability of the costs related to the continued operation of San Juan Generating Station Unit 4 through September 30th, 2022, including fuel costs. The Commission reserves its full authority to review any rate recovery in the future. I stand for questions.
Thank you, Michael Smith. Any questions for Michael Smith? All right, if not, do I hear a motion to approve the order as presented by Michael Smith?
Mr. Chair, I'd like to move that order.
Okay, we have a motion on the floor by Vice Chair Hall. Do I hear a second?
Second.
We have a second by Commissioner Teresa Vicente Aguilar. Any discussion on the motion?
Mr. Chair.
Commissioner Byrd.
Thank you. Thanks, Mike, for the order and all the work you put in this last week to get it here. So I happen to agree with New Energy Economy. I think their questions are spot on. I add to those, what assurance do we have that when they've actually walked away from San Juan, you can't just keep it running for a few more months, that we won't have the same issue next summer? This appears to be a Band-Aid fix. Also, being that we've heard that they will have reserve margins and they will not have reserve margins, what is the real answer? And I believe that's why New Energy Economy is opposing this, is that there's some serious questions on what we've been hearing and what we're being told. And it's, consistency issues. I've always said that although the principle behind a order or new legislation is a good one, if it's not written well and doesn't really answer the real concerns and the causes, is that an adequate fix? So I think there's a lot left out there that really should be answered, that we're not going to be able to do in a quick approval order such as this. Thank you, Mr. Chair.
Thank you, Commissioner Byrd.
Chair.
Any other
Mr. Chair.
comments? Commissioner Fishman?
So I guess partially for clarity for the press and all, and also just to cement this in my own mind, what's happening here with this order is that we're saying yes to continued operation of San Juan through the summer of units 1 and 4. We're saying that the costs that might be incurred, particularly fuel costs, because of that, we're going to judge further down the road whether what the cost recovery should be for PNM. That is now undetermined. We're saying that basically, and thank you to Mr. Gatko from the AG's office for the excellent questions he asked. We're saying that it appears the appropriate work has been done to be sure that 1 and 4 can stay operational. And in a nutshell, that's what our decision is. So, Mike, I'm going to just ask you to comment on that real quickly. Is that correct?
Mr. Chairman, Commissioners, the only clarification I would make is that we're not saying yes in this order, because yes would be conferring an approval on PNM's actions. What we're saying is that under the terms of the Commission's orders that were issued, and based on PNM's ability to control its abandonment, that the Supreme Court, the timing of its abandonment as a voluntary action, as the Supreme Court has confirmed, the Commission's orders don't require PNM to abandon the plant by a specific date.
Right.
And PNM's actions in deciding to extend for a few more months that abandonment will be subject to subsequent review by the Commission at the time that those actions, the rate impacts or cost impacts of those actions will essentially be put into effect.
So we're saying if they can make it work, then go ahead, as opposed to approving or disapproving. That would be the distinction.
Well, I wouldn't even say we're saying go ahead. What we're saying is they have that authority in operating their plant to make these kinds of decisions.
Okay.
And whether the timing of their approved abandonment is something that they have the power to determine, and those actions that they take will be subject to a prudence and reasonableness review later.
Okay. Sounded good. And I just want to make the comment that based on the responses, there was a lot of agreement between the parties about taking this course. So I feel very comfortable with it. I share the peak that New Energy Economy expressed in its submission. I'm going to just say this one more time, is that at their February 3rd meeting, the CEO of PNM was saying, gee, we got it all covered to the shareholders and to the analysts. And in the meantime, they were having discussions with the press saying, well, we're not sure. It still might be uncertain. It feels like in terms of messaging, different audiences, we're getting different messages for different purposes and different agendas. And transparency and clarity is important. And when these different messages go out, it creates a lot of work for all the other parties and stakeholders involved, and as well as stress. And I think that PNM needs to perform much better in terms of clarity and consistency of its communications, so they don't create issues or problems that needn't have been created. And well, I'm happy that they, and this wasn't the original hope. I mean, PNM hoped that we wouldn't have to extend the use of the coal plant, but, and I'm happy they managed to pull something together that appears will handle this problem. That's great, but the communication side of this was awful. The transparency was awful. The clarity was awful. And they take a very dim view of that. And we need to ask for better going forward. And in fact, not just ask for better, we need to require better. So with that, I'll shut up.
Thank you, Commissioner Fishman. Vice Chair Hall?
So I beg your pardon? You can hear me, right?
Yes.
Okay. So I just wanted to state that I think this is a very good outcome too. And I really hadn't appreciated that the nuances of the Energy Transition Act provisions that basically leave it up to the utility, to PNM in this instance, to not only decide when to abandon the plant, but if to abandon the plant. The only driver for abandoning the plant is if the utility wants to enjoy the benefits of securitization. And if they wanted to forego those benefits, then there's no prohibition on the utility even continuing to run the plant beyond that time. There's no date in that statute. So my understanding from the long discussions with Mike is that this is a desirable way to leave it, wherein we just acknowledge that they have that ability to do that. We take notice of previous orders in which we've acknowledged that they have set themselves a deadline. And it's the ball is basically in PNM's court to make the securitization process work and to make sure there are adequate resources to provide reliable service. I will say, sort of echoing Commissioner Fishman's comments, that I do feel there was some fear mongering going on, because during the time when warnings were going out about rolling blackouts, that was at least 10 days or 2 weeks following when the utilities CEO had already announced to investors that they had the summer of 22 resource adequacy covered. And I agree with Commissioner Byrd that this is not the best performance by the utility during this summer. They have enough. They have also delivered information to us that indicates that they have adequate firm capacity in combination with the use of San Juan to be in a very good position for this summer. But as we know, we're looking beyond just this summer. And the reason we have our combined dockets on supply chain and resource adequacy is so we can continue to hold their feet to the fire and give us the real facts about how they're going to have resource adequacy going on into the future. This is not a short-term circumstance. We'll have the kinds of climate disruptions going on in the future. We can expect the supply chain to improve. The supply chain is causing delays, but we can anticipate that those delays will be caught up, not in the short term, possibly over a year or two. So PNM bears a burden to make sure they secure firm resources in advance, more in advance than they were doing this summer for next year. But I think this is an excellent resolution this time. And I appreciate the efforts of everybody involved, including the Attorney General's office, who has a very pivotal and significant role to play in our cases on behalf of consumers, especially residential ratepayers. So thanks very much, Mr. Chair.
Thank you, Vice Chair Hall. Any other comments? And just to recap, we do have a motion and a second on the floor to approve the order as presented. Yes, Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. I would like to state for the record that we want to say thank you to Michael Smith and the Office of General Counsel to look at the final orders that were issued in April of 2020. And they clearly stated that PNM has the authority to voluntarily shut down San Juan Generating Station when they are prepared. And PNM has the authority to request a variance when a crisis is suspected, like, for example, this coming summer. I think most importantly, I would like to state that when ETA was passed, we're not a state like California. And I think I have stated that before. New Mexico is different. We are built on a foundation of diversity, and we believe in our culture and our values, that anytime there is a change, New Mexicans change at a gradual process. And this is a perfect example. That's what I stand on. I knew all along that when ETA was passed, that it's not going to change overnight. All the different portions of the process is going to be solidified when the time tells us. And that's the way I see the transformation of energy renewable projects throughout the state of New Mexico. And so this is just my point, that having a Native American at the seat is, and to remind all the utility companies and everyone in New Mexico that we are proud. We are proud of who we are, and to think for our neighbor, to allow the power to be continued, to be utilized. And thank you, Mr. Chairman. I'm just proud to be part of this commission today. Thank you.
Thank you, Commissioner Vicente Aguilar. Any further discussion? I did have a question for Michael Smith. Michael, several interveners brought up the issue of the energy transition bonds and when would the appropriate timing be best given the anticipated increase in interest rates. And so obviously, you have, laid out kind of the provisions of the order and the ETA. If this plant is not abandoned by January 1 of 2023, they can't take advantage of the benefits to recover stranded assets through the energy transition bonds. So can you just speak to that issue? When might that happen? Or is it really up to the commission or is it really up to PNM? Can you just speak to that issue that was raised by at least a couple of interveners regarding timing of the energy transition bonds?
I'm afraid I might get myself in trouble on this, but I think my understanding is that the energy transition bonds are authorized under the Energy Transition Act only to the extent that there is an actual abandonment of the plant. And that was the point that I was making when I was referring back to the qualifying generating facility definition requires an abandonment prior to January 1st, 2023. Other than that, the timing by which the utility determines to issue those energy transmission bonds to recover the energy transition costs is within their discretion and their control under the order and the Energy Transition Act.
So with this is, I guess, a partial abandonment because the request is to continue operating only one of the two units. So is it an all or nothing, or can a partial abandonment establish the green light to begin processing energy transition bonds?
That's a question that I'm not sure I can really answer at this time, given that hasn't taken place, and I'm a little hesitant to give an advisory opinion on that.
Okay, I don't want you to get in trouble.
Mr. Chairman, Commissioners, well, I did want one thing I did want to clarify, though, just in terms of when I'm referring to the Energy Transition Act in the discussion that I just had in the order, I am referring specifically, and you've heard me, this is sort of a mantra I've done in the past, but I'm referring specifically to section 6218.1 through section 6218.23, which is specifically the Energy Transition Act, and that governs the securitization process and the issuance of energy transition bonds to recover energy transition costs. I'm not using that term in the colloquial sense, I guess. I don't know if that's really the right term, but in the sense that certainly the bill was promoted, Senate Bill 489 was promoted at the legislature, and people sort of commonly refer to the Energy Transition Act and the corresponding other provisions in Senate Bill 489 that instituted changes to the, to the renewable portfolio standard and other statutes. There are provisions in those statutes specifically that the change in the renewable portfolio standard and the changes contemplated to the air quality standards that ultimately will compel the utility to abandon its coal generating facility. But when I'm saying that the Energy Transition Act does not compel that, that's what I'm referring to is specifically 6218.1 through 23.
Michael, I think what this order does is it avoids summer blackouts, and I think this just reiterates, I think, our commitment to work with utilities to help keep the lights on. Now, there will be questions down the line, but And I think we allow for that in this order, not just through the next rate case, but through some open dockets that are germane to this issue. I also want to recognize the interveners understanding the gravity of the situation and agreeing, not to contest this. I also want to commend the co-owners of San Juan Generating Station for agreeing to amend the operating agreement, and to Westmoreland in their cooperation to amend the coal supply agreement. And so that takes a lot. That takes a lot of work to do that. And I also want to reiterate too that there's still concerns regarding resource adequacy planning, especially for summer of 2023. In light of our recent approvals regarding replacement power for the Palo Verde leases that were abandoned by PNM, and the agreement to allow Unit 4 to continue operating until September 30th of this year at the San Juan Generating Station. I would like to see a revised load and resources table to reflect these two energy sources, so we can see what the reserve margin would be going forward. My understanding is with the continued operation of Unit 4 in this action that we will have a very comfortable reserve margin, well over, I think, the 12% that PNM had been operating under thus far. So I think it assures us that the lights are going to stay on and that we're going to avert blackouts and that we're going to continue addressing resource adequacy planning, and in conjunction with consequential delays from the supply chain issues that may curtail emergency response and the restoration of service, particularly in the service areas of our rural electric co-ops. So with that, any further discussion? We have a motion on the floor and a second. Any further discussion? All right, Russell, please take the roll call vote.
Commissioner Fishman,
Aye.
Mr. Chairman,
Aye.
Commissioner Hall,
Aye.
Commissioner Vicente Aguilar,
Aye.
and Commissioner Byrd.
Aye.
Mr. Chairman, the proposed order is adopted unanimously, 5-0.
Thank you, Russell. Thank you, commissioners, and thank you, Michael Smith, for a very thorough job on that order. All right, we deferred action on item 10. So we're on to communications with the Chief of Staff. Wayne, are you there?
I'm here, Mr. Chairman. Good morning. Good morning, commissioners. Nice to see everyone. Looks like we'll wrap up a little early today, which is nice after the last several weeks. I don't have a whole lot, still kind of decompressing a little bit from the legislative session. So I just don't really have a lot for you this morning, Mr. Chairman, but certainly happy to talk about anything you or other commissioners would like to discuss or answer any questions you might have.
Thank you, Wayne. Any questions for Wayne?
Mr. Chair.
Commissioner Byrd.
Good morning, Mr. Protz.
Good morning, Commissioner.
Having nothing to say is always a great answer. Thank you, sir.
If, Mr. Chairman, you can ask my wife. I'm very good at that.
All right, anything else for our Chief of Staff?
Mr. Chair.
Yes,
Vice Chair
Mr.
Hall,
Chairman.
and then Commissioner Vicente Aguilar.
Mr. Chair, I just wanted to thank the Chief of Staff for his hard work during the session and keeping us informed about bills and what was happening. I know I ended up talking to him one night around 8 o'clock, and he just picked up the phone right away, and he was there ready to talk about the bill. So I was pleased with that, and I know he's working at it very hard. So I just wanted to thank him for it. Thank you very much, Mr.
Thank you,
Protz.
Commissioner. I appreciate that.
Commissioner Vicente Aguilar.
Thank you, Mr. Chairman. Our Chief of Staff, Probst, thank you. I want to echo what my colleagues are making remarks on, the good job that you are doing, especially after the legislative session. And most importantly, I think you have a good control over the staff members, because lately all I had to do was call them and they immediately have an answer for me. So Mr. Probst, you're doing a wonderful job. Thank you.
Thank you, Commissioner.
Anything else for Wayne? And Wayne, I'd be remiss if I didn't mention the outcome of our budget request for FY 2023. As I understand it, we did get approval for about half of the increase. I think our requested increase in our budget was about 15%. We got about a little over 7%. Can you just recap that outcome?
Sure, Mr. Chairman, members of the commission. Actually, with the additional funding that we received for FY 23, when House Bill 2 got to the Senate Finance Committee, the overall increase to general fund was closer to 10%. And I think the overall increase to our FY 23 budget was a little over 9%.
And Wayne, can you just summarize what that can really allow us to do as an agency?
Sure, Mr. Chairman and members of the commission. I mean, from my perspective, the most important thing that it will allow us to do is have funding in 3 key areas. First and foremost, to fill any vacant positions that we have. Second of all, to have sufficient contractual services so that when things come up, we're able to respond quickly and bring in additional expertise or folks that can help the commission with particular issues. That's something we've had a big challenge with this fiscal year, as you know, Mr. Chairman. And then third, from my perspective, it will allow us to provide training and continuing education to the staff that we have here at the commission. That again has been an area that we haven't always had the resources that we need to provide those opportunities for staff. So those are the 3 key areas. In addition to the increase in our FY23 budget, we also received appropriate authority to retain up to $500,000 in application fees under the Community Solar Act. That will hopefully allow us to get that program off to a good start. And we also received some additional program transfer authority for FY23, which provides significant budget flexibility that we haven't had in the past. So we could always ask for more, we could always get more, but as chairman and members of the commission, I feel very confident that we will have the resources we need for both ending the current fiscal year, but also in FY23 to do some things that we haven't perhaps been able to do in the past in those 3 areas.
Thank you, Wayne. Anything else for Wayne? Appreciate your work.
Thank you, Mr. Chairman.
Let's move on to communications with General Counsel, Michael Smith.
Mr. Chairman, Michael has reported to me, we do not have any communications.
Okay. Any questions for Office of General Counsel? I guess Russell will field them. Any questions? All right, let's move on to communications with commissioners. Anything from commissioners? Wow. All right, well then hearing none, thank you everyone. We are adjourned. Have a great day.
See ya.